Please, Your Ladyship. My learned friend's submissions in this case, as it were, reduced to their basics, are this lease, if enforced according to the Court of Appeal's decision, would be very inconvenient for landlords, so please will this court rewrite it. Because the essence of the case with regard to looking at the context, looking at the difficulties and so on and so forth, is to say clause 319 as written presents problems which can be avoided by, in effect, writing the clause out of existence. Although my learned friend does not contend, contrary to contentions which have been raised in the past in this case, that 319 ought to be treated basically as a dead letter by the court, nonetheless, the conditions under which clause 319 is operable, if my learned friend is right, would be such as, to use Lord Justice Lewison's phrase, to rob it of all commercial value. I can't the exact words, but it would be of no commercial concern. One has to look at it also in the context of the landlord's position here. This is not a commercial landlord who is, so to speak, letting out the properties for a rack rent and deriving an income from it. As the court has been shown, the reservation here is of 1 peppercorn, and the only other sums that the landlord is entitled to charge are service charges, which of course are all related to expenditure by the landlord company in the management of the flat, and those service charges are in effect being passed on to the tenants. So the only value, in inverted commas, to the landlord of this property is that sometime, and I haven't done my maths very well, but sometime in, I think it's 2101, this, by then, very dilapidated building, aged building rather, will be available as a freehold or a freehold site. So in the interim, the landlord is simply...
But even that isn't inevitable, is it? Because there's a right to extend leases.
Indeed, the right to extend might extend it into a very far distant future, so that the reversion, essentially, the reversion to this property is, to all intents and purposes, irrelevant to the questions that we have to consider here. The position, therefore, is that the landlord here is, in a sense, simply managing the building. It is a management company. In this particular instance, it is a management company, as is often the case, where the owners, in inverted commas, are the shareholders of the company who are the tenants of the flats. So the tenants, each flat owns a share, therefore each flat has a right to vote at general meetings of the company, to elect or remove directors and so forth. Now, this situation does not depend, or there is no change arises, whether this is a situation as at Randolph Crescent, where there are 9 flats and 9 leaseholders who know each other for good or ill. It applies equally to a block of say, 200 flats, where the tenants may not see each other from one year's end to the next. Many of the flats may be lawfully sublet or owned by parents for the use of their children, or even owned by limited companies which use them for the residence of directors and employees, so that the size of the block of flats is irrelevant to the construction of a clause like 319, because it is common ground that clauses like 319 are to be found in a large number of leases, not simply leases where the landlord or managing company is a company owned and controlled by the tenants themselves.
So the fact that the landlord in this particular case is a company owned and controlled by the tenants themselves is also irrelevant.
It's irrelevant to the construction of the clause, yes. Our fundamental argument on the construction of clause 319 is that it is a clear, unequivocal clause on its face. It does not require anything that the law would properly classify as an implied term. An implied term comes into play, and if I can quote something that Lord Hoffman said in the Belize case, question of implication arises when the instrument does not expressly provide for what is to happen when some event occurs, which is, we would submit, a very good encapsulation of why you need an implied term. You need an implied term because the contract does not spell out what happens in a given event. In this case, in our submission, clause 319 spells out quite unequivocally what is to happen in a given event. If there is a breach of a covenant or an apprehended breach of a covenant, any tenant by one tenant, any other tenant can go to the landlord, the freeholder, and say, please enforce this covenant. And providing the objecting tenant is in a position to offer, or if called upon, to provide the relevant security, then the landlord has no choice but to enforce. I'm not wholly certain that this is my friend's position, but I think it was accepted that in the event of a tenant coming along at a time when the breach has not yet been committed and no license purportedly granted, that at that point it is open for the individual tenant to say, I am exercising my clause 319 rights, here's the security, you stop it, you enforce this covenant. Now, the problem with the approach urged upon you by the landlord in this case is that the landlord seems to posit a situation where the obligation to enforce a covenant only arises when a demand has been made. Therefore, if prior to that time the landlord can, so to speak, get his blow in first and grant a waiver or license or variation of the covenant so that what would otherwise be a breach ceases to be a breach, if the landlord can do that, he can in fact stymie the objecting tenant. Because by the time the objecting tenant comes along and says, Mr. X, my next door neighbour, proposes to do so-and-so in breach of clause 27, the landlord can simply say, too late, I've authorised it. Now, this is not clearly a satisfactory situation. It is clearly not a situation that I would respectfully submit a court would necessarily want to write into a lease if it could be avoided. And we would submit that that is because to adopt that construction would be to do enormous violence to 319. The purpose of 319, as we say in our written submissions, is to provide a policing mechanism for the lease. As my learned friend rightly says, of the three types of lease which she posited, the third was a lease where the enforcement of the covenants was purely a matter for the discretion of the landlord. The tenants did not have any equivalent of 319, and because it is not a letting scheme, they could not themselves sue the defaulting tenant for the breach of covenant. So the effect of what my learned friend is arguing here, and was argued below, the effect would be that you are turning this lease, category 2 lease, which has a clause 3.9 enforcement provision, into a category 3 lease where enforcement is purely at the discretion of the landlord. Now, our submission is that that is to do very considerable violence to the policing mechanism of this lease. Now, it is said, perhaps very cogently, by my learned friend, well, this is a building of which a lease has been granted for 125 years. It was a building of some antiquity when the lease was granted in 1986, being then probably about 100 years old. It's going to need modernising, and so on and so forth. Now, it would be very prudent, of course, if you were drafting a lease, as of today, from scratch, to build in some form of what I think is known as future-proofing, or at least you would have some sort of provision which enabled both the tenants and the landlord in the future to introduce technical innovations that may be invented between now and 2101. That would no doubt be very desirable. But if, and this is a contract, if the parties to this contract have not decided to future-proof it, then in our respectful submission, a court cannot come along 33 years after the lease was made and say, well, you should have future-proofed it, and we will alter, in effect, the structure of this lease so that you can.
It's not just future-proofing. It's not about changing technology. It's about ordinary things which, changing the layout of a bathroom or something, and moving the radiators. And apparently,
that is undoubtedly true, and it is also undoubtedly true that if you applied clause 2.7 absolutely literally, then in practice you could stop people changing radiators. Unfortunately, that is how clause 2.7 is drafted.
Well, can I just ask you this? Are we to construe this on the assumption that this is a relatively small property where, as you say, the parties may be expected to know each other and reach some sort of agreement? Have we got any reason to construe it as though it might be contained in a property which has 200 units? I mean, we surely have to deal with it in the terms that we find it, don't we?
Yes and no. Yes, that is the factual matrix of this particular agreement. But no, to the extent that although this is a small, relatively small block of flats, if I can put it that way, 2 converted houses, it was common ground that this form of lease was common to the whole of the Church Commissioners' estate in Maida Vale, which they were developing, or rather, is developing and selling on in the 1980s. So that it is not simply, it is not a one-off lease confined to Randolph Crescent.
No, but I mean, it's one thing having a lease of a property with not more than 10 units, where there's at least some prospect to be able to get the consent of all the other people in it. It's quite another thing, something like Dolphin Square or something where you've got hundreds of leases. And I mean, are we bound to assume that would have, that this clause would be found in that sort of property?
Well, it seems to be agreed in this case that a clause of this kind is found in large numbers of leases, of flats of various sizes, of blocks of flats of various sizes. Obviously, without wishing to give evidence myself, I have a very similar clause in my lease, and the block I'm in has got something like 189 flats. So it is.
I see. Well, maybe if that's common ground, a bit.
But I would, attractive though it might seem, to say, oh well, we look at it in the context of this property, which there's a relatively small number of people, they may all know each other, they all participate in a very small limited company.
No, but in a way it's a point in your favour, because at least where you've got a small number, then it's reasonable possibly to think that the parties may be able to agree on inconsequential changes. But in the case of your own property, it's almost impossible to get the consent of everyone.
Yes. And that, I think, is the reason why one has got to look at these clauses in the abstract, because it would be very, very difficult to draw the line where would you draw the line? Is it 10 flats, 20 flats, 30 flats, 50 flats? I agree, when you get to 190 flats or something like that, getting everybody to agree would be quite impossible, logistically, even if not otherwise. But it would, our submission is that the construction of a clause which has been used as a standard clause, certainly by the church commissioners in this form, over a large area, and also is found in a very similar form in leases of all sizes of properties, and is included in leases, and I think my Lady Black mentioned leases in which the landlord is not a company controlled by the tenants.
No, I'm sure that's right.
Yes. So in this particular case, there is the possibility, I would accept, of all the tenants, as it were, agreeing not to enforce the clause 2.7 in a harsh and oppressive way. The downside, of course, of having a small block of flats with only 9 or 10 flats is that there might well be personal animosities which play out in whether or not permission is or is not given to carry out certain works. The advantage of our construction of clause 319 is that this avoids, as it were, personalities. This is a legal right imposing a legal obligation, and therefore and clause 2.7 is an absolute covenant, intended to be an absolute covenant, not a covenant if the landlord thinks it would be a good idea to vary it, or if the landlord thinks a good idea to waive it. Because another of the points that is not, that was raised by members of the court in argument, but has not been satisfactorily answered, we would submit, by the landlord in this case, is on what principles would the landlord act in deciding whether or not to license, and I include by that consent, license, vary, lease, license works that breach 2.7. Because if the landlord is not obliged to act reasonably. Reasonableness on the part of the landlord is imposed in respect of clause 2.6, and indeed the clause that to which the court was taken in respect of assignment of the lease. Consent not to be unreasonably withheld, and been taken to the 1927 Act, which in effect wrote not to be unreasonably withheld into clauses of that kind. But that imports an objective standard of reasonableness, and as my learned friend rightly says, cases on whether landlords are or are not unreasonably withholding their consent have been a lucrative source of occupation for the landlord and tenant bar, certainly as long as I've been around. But they are not seeking, as I understand it, to build any concept of reasonableness into clause 2.7 and any license granted to breach clause 2.7.
Well, not that concept of reasonableness, but they point out that there are various other constraints upon the landlord that would stop the landlord licensing certain things that would put the landlord in breach of its own covenants in relation to the property.
That is undoubtedly true, my lady, but they are very limited. And certainly they would not impinge on a case such as this, with where works are being carried out internally to a flat, but involve the removal of load-bearing walls. Under what principles would the landlords act? And what is more, if the landlords have a complete discretion and they decide to license these works, and as a result of the works being licensed, the building is damaged, that is not totally unreasonable in this case, because the works that were proposed involved removing, I think, some 7-metre length of load-bearing wall in a basement flat on buildings that were originally put up by speculative builders on marshy land in Maida Vale. So the risks that are of problems with the building caused by works of that nature were not wholly fanciful, and this is why there was an argument about insurance, which led to the parties, so to speak, falling out. But assume that the license had been granted to the Winfields, the works had gone ahead, and the building had suffered subsidence. Would the other tenants who had suffered from this have any remedy against the landlord?
Well, that would depend upon the proper interpretation of clause 2.7, wouldn't it, and whether it's possible to depart from it.
Well, assume that it is possible to depart from it, assume they do depart from it, and it all goes badly. Does this mean that the tenant has no right of action against the landlord for, in effect, granting permission which has turned out badly? Now, if our position is correct, then the landlord cannot grant permission, so the problem never arises. But if my friend's position is correct, then the landlord must have, on that hypothesis, a complete free hand, carte blanche, I think is how Lord Justice Lewison put it in the Court of Appeal, carte blanche to do what he wants, subject only, as my Lady Hale has said, to the other constraints imposed by the lease. And in our respectful submission, you have only to contemplate the prospect of a landlord having carte blanche to see, first of all, that it is unworkable, and secondly, that it drives a coach and horses through 319. Now, it is said by the landlord in this case that we, for the tenant, are seeking to impose, or ask the court to impose, an implied term in this case. This has never been our case. I'm not suggesting that the court turns it up, but if the court were for interest to turn up our original, very brief, I have to say, points of claim in this case, the words implied term do not appear. Our case was and is that by purporting to grant a license, however phrased, to breach clause 2.7 or any other absolute prohibition, the landlord is acting in breach of a primary obligation, not an implied obligation, but a primary obligation, which is to enforce such covenants if called upon to do so.
I think you made it clear earlier on, you regard enforce as including taking action against an apprehended breach.
Yes, indeed. I was about to come to that, but because one starts with the proposition that what the tenant proposes to do would, absent any form of permission from anyone, be a breach of the lease, a breach of covenant, a breach of contract. And there is no doubt that at that point, the landlord could forbid the tenant to do it. So that if Mrs. Winfield goes to the landlord and says, I wish to remove this load-bearing wall, the landlord is entitled to say no, and as my friend concedes, there will be nothing Mrs. Winfield can do about it. If, on the other hand, Mrs. Winfield goes to the landlord and says, I propose to carry out substantial redecorations under clause 2.6, and the landlord unreasonably says no, then Mrs. Winfield can take the landlord to court and get a declaration accordingly. But with clause 2.7, if the landlord at that point says no, you can't, then anyone who goes ahead and does it is in breach of contract. If prior to that point, the Winfields say, well, we don't care whether you say yes or no, we're going ahead, and the builders are coming in on Monday, then the landlord would be obliged to obtain an injunction to prevent the building works from starting. Now, clearly in the context of this case, if the landlords had said no, there would be no question of Mrs. Winfield saying, well, I don't care what you say, the builders start on Monday. But one can imagine a situation in which a tenant might take that stance. And if a stance of that kind was taken, then, and I think this is a point that my Lord Lord raised earlier, then you would obtain a quia temet injunction to prevent a breach of contract. This plays in to 319. The reason why we say 319 must necessarily preclude the landlord from granting consent is because by granting consent, the landlord commits, we would say, an anticipatory breach of clause 319 by putting it out of his power to enforce against the tenant. The cases on breaches of that kind are quite clear, stemming back to the earliest breach of promise cases. If you do an act which disables you from performing your contract when the time comes, it is irrelevant whether the conditions required for performance have yet been met, what the contingency contracts. I don't think I need to take the court to it, but the court may recall in the first of the breach of promise marriage cases, there was this rather strange arrangement where the man says to the woman, I will marry you if called upon to do so within a reasonable time of your calling on me to do so. A curious case of what might be termed a matrimonial option. Presumably, if the lady never called upon the gentleman to marry her, he would have died an old bachelor. But that was the nature of the contract. Now, the argument that was put before the court was, well, at the time this gentleman went out and married somebody else, the original lady had not operated the condition. She had not gone to him and said, name the day. That was still in the future. And it was therefore said, well, this was a contingent contract. The contingency had not yet arisen. Therefore, at that point, the man could not be in breach of contract because, as it were, the conditions and time for delivery had not yet arrived. But the court rejected that, and the Court of Appeal in this case also rejected that. There was considerable dispute below on the question of whether or not Dr. Duval had offered security. Your Lordship is not concerned with that at all, because Lord Justice Lewison said, I will proceed on the basis that she had not. In other words, I will proceed on the basis that the condition precedent to the actual application of 319 had not yet arisen. So at that point, you ask the question, as in the breach of promise marriage cases, you ask the question, if I, the landlord, grant permission to the tenant to breach clause 27 or any other absolute clause, I am putting myself in a position where if a tenant now comes along and says, please enforce, I say, nothing to enforce, because I have waived the covenant.
You say we're not concerned with what the factual position is. I mean, Lord Justice Lewison was able to proceed on a certain basis, given his ultimate conclusion. If we were to take a different view from him on the legal position, then are we then leaving it to the parties to try and sort out whether the condition was fulfilled or wasn't fulfilled?
Happily no, because events moved on. The Winfields, so to speak, withdrew their proposal.
Oh, I see.
Licence was never granted.
I see, so it's all academic.
I'm sorry,
Do we know? We know that they withdrew their proposal and they did something less radical.
There's something less radical.
Do we know whether that technically involved any breach of clause 2.7?
The answer to that is it almost certainly did.
Yes.
It was almost certainly a very minor one, and nobody took any objection under 319 whatsoever, and this was in effect by the ultimately by the tacit consent of the tenants, this was permitted to go ahead. We have never disputed, and indeed it's common ground between us, that if all the tenants do agree that something should be done, or that a clause is not to be enforced, then of course they're at liberty to do so, and no question arises. So the answer is...
What if you said two different things then. You said if all agree, that's fine, but you said that what happened with the Winfields alterations was that nobody objected.
There were initial murmurings, but nobody pursued any
Nobody
objection.
took
And certainly
319.
nobody raised 319. There was no 319 objection to the reduced works. And of course...
On your interpretation, as someone, an absentee tenant who came along a year later and discovered this had been done without him knowing about it, would be able to take action compelling it to be put right?
Not necessarily. The remedy, what we say is, if there is an obligation to enforce which is not carried out, either because a license has been granted or simply because they don't enforce, then that is a breach of clause 319. What the remedy for a clause breach of 319 would be is entirely dependent on the gravity of the offence, so to speak, and the effect on the claimant. If the claimant is being purely a dog in the manger, then he may find that he's got the landlord in breach of contract, and the court says, so what, nominal damages, and all he ends up is with a very large bill of costs. The policing mechanism is partly contractual. 319 provides the policing mechanism. The way it works out in practice is factual depending on the circumstances. And this, in our submission, robs the dire effects of the absolutist position of much of their teeth, because we have to say what will happen in practice. You are concerned, of course, with the construction of the clause as a contractual clause, but it is necessarily part of the context that if an objection is taken frivolously, then the person who takes it may end up with a large bill of costs and nothing to show for it. Because if, for example, the breach of clause 2.7 were trivial, very minor, then enforcement would be quite impractical in the courts. And if the objecting tenant insisted the matter be taken to court, then the objecting tenant would end up with a very large bill of costs and no result. So that it is...
Can I just ask, would one get into, I don't know, Lord Cairns Act territory? So suppose the proposed works do involve a breach of clause 2.7, but it's trivial, it's not affecting anyone else. But another tenant operates clause 3.19 and says to the landlord, I'm giving you the money to enforce, please now enforce. Presumably the landlord then has to go to court, I assume seeking an injunction.
And if that's refused, no doubt the landlord will be ordered to pay costs which will be passed on to the objecting tenant.
Right, but my question really was, if we get to that stage and the landlord is taking proceedings for an injunction, would Lord Cairns Act have the effect that the tenant who's affected the alterations would be able to defend themselves if there really is no prejudice to...
Damage is a sufficient remedy.
Yes, that was my question.
Sorry,
Is that the way it would work, is my question?
Undoubtedly, yes. Because if the works have already been carried out, then the only remedies would be damages or reinstatement. And reinstatement would be likely to be ordered only in rather extreme cases. Of course, in practice, certainly the difference between a small block and a large block is that in a small block, in practice, such as this, the tenants would be likely to get wind of the proposal, not least because one of the tenants themselves will be on the board of directors to whom the application must be made. It is very unlikely that it would not get round what was being proposed. But clearly there would be a problem in a large block of flats that this might not happen. Assume the tenants get to know what's happening. One tenant says, I'm sorry, I don't like this. I'm enforcing my rights under clause 3. I'm applying my rights under clause 319. You enforce. Now, at that point, all the enforcements that are required of the landlord is to say no. That's all, and it's common ground that if the landlord says no, that's the end of the matter. The tenant cannot compel him to say yes. So that, in effect, the only way in which 319 is going to lead to what might be termed a hot war rather than a cold war is, one, if the landlord and tenant persist between themselves in saying these works must go ahead, in which case the objecting tenant can say to the landlord, sorry, no, you must obtain an injunction. Or if the works are actually carried out, in which the objecting tenant says to the landlord, you must enforce this by obtaining damages or, in extreme cases, a reinstatement order. But in most cases, it will be sufficient for the objecting tenant to say, I know that Mr. Jones is proposing to do X. I object. It's a breach of clause 27. I object. Or indeed, it could be another breach. I know that my next door neighbour proposes to have an all-night rave or 3-day rave in his flat. I want this stopped. And you go to the landlord and say, this is a clear breach of the Schedule 5 covenants about noise and so on. I want you to enforce it. It's an absolute covenant. I want you to enforce it. And the landlord would then have to enforce it, either by saying, no, you must not do this, or if the tenant said, I'm going ahead anyway, taking court action to stop him. So we're not wholly concerned here with clause 27 building works.
No, there's a great many absolute covenants.
There are many, some trivial and some really quite certainly, and covenants, for example, about change of user and so on, which might well impinge on the other tenants.
Well, I mean, you're basically saying the landlord couldn't give permission to a tenant to take in a lodger, because that would be a breach of the covenant in 211, no matter how sensible, reasonable and appropriate that was. They couldn't give permission not to lay carpets all over the place, in breach of 2.12.2.
Yes, I'm afraid that is, but my answer to that is, these are long leases sold for substantial premiums. Those who bought them, this is what they bought. If you buy a Ford Mondeo, you can't complain it's not a Rolls Royce. This is what they have signed up for. And if a lease does not contain a mechanism for varying absolute covenants, then they remain absolute. That, I'm afraid, is the consequence of the contractual provision.
But I mean, yes, I mean, it's not very helpful to compare it with buying a Ford Mondeo or whatever it is. I mean, the problem about these lease cases is the tenant in practice, if he wants to buy a nice flat in this area of London, probably has no choice. I mean, they're probably all ex-Church Commission leases, all in the same form, and he either takes them or leaves them. And so one hopes that there is a sort of an approach to them which produces a reasonable result. But I mean, the trouble about this sort of case is you find two equal and opposite versions of what is a reasonable result.
Lordship, if I may say so, as put your Lordship's finger on the point, you might expect that there would be a reasonable and proportional approach to it. And I imagine that in 99 cases out of 100, that is what you would have and find. And that's why these cases, it's very rare that something like this gets before the courts at all. But the mechanism of the lease is, this is how it's policed when things go wrong.
Can I ask you a slightly different point going back? I mean, I find it slightly unsatisfactory when being asked to decide your point of principle by reference to sort of breach of promise cases in marriage of some antiquity. Indeed, the earliest case you cite, at least the most recent case you cite, is from the early part of the last century. I mean, we can find in Chitty, I mean, I see how the textbook writers deal with this, and don't you want to refer us to that? I mean, I was looking at page 1330 of the bundle. I don't know who put that in, but there's quite a pithy statement by Chitty of prevention of performance. I mean, I'm not sure whether you rely on that or the other side rely on it or what.
Sorry? Tab 20, thank you.
1330.
Yes.
And I just do find it helpful to have a sort of an up-to-date textbook reference.
Yes, indeed. Lord, prevention of performance. Prevention of performance, there are basically two strands to prevention of performance.
I mean, do you adopt that? Do you think that particular paragraph supports you, or?
Yes, it does, because that is a citation from Sterling and Maitland.
Well, the citation supports you, but the caveats that are later on in the paragraph are slightly less supportive.
Yes, and this is, I think, the problem, that when dealing with prevention of performance, whether or not something done by the contracting party prevents him carrying out his promise is, in most cases, a purely factual matter. So you have a considerable number of different factual circumstances in which that has or has not happened. And again, there are two further strands. There is prevention of performance by act of the person who is due to perform, and then you have prevention of performance by the other side, which is, I think, the Ukraine case. We're not concerned with prevention of performance by the other side. This is somebody putting it out of his own power to perform his contract. And it would be the same as, for example, of somebody who has contracted to sell goods, but before the time for delivery has arrived, sells those goods to a third party. Now, the third party may, depending on the nature of the third-party contract, obtain a good title to them. But nonetheless, the sale by to the third party has put it out of the seller's power to deliver those goods to the original buyer, and therefore he is in breach of contract, even if only as a remedy being damages. So that by taking an inconsistent act, so that when the time for performance comes, you cannot perform, that is the circumstance in which, whether it's a rule of law or a rule of construction, you have already breached your contract.
Yes, but what I'm trying to get at, is this the best textbook statement of the rule of law on which you rely? If not, can we find
No.
a better one?
No, I would never dream of questioning Chitty. No, in fact, this is as good as you will get, because the reason is that performance by act of the person who is due to perform, which disables him from performing the contract, is a relatively rare occurrence.
But does it matter that in the cases you've been describing, what is disabled is the whole fundamental performance of the contract, whereas here it is a disability to perform one term of the contract?
My lady, I would submit that makes no difference whatsoever, because this is a freestanding obligation on the part of the landlord, and therefore he disables himself from performing that obligation. This, if I may say, it was the fallacy underlying my learned friend's argument on anticipatory breach, that my learned friend treated anticipatory breach as being simply a breach which is so serious as to entitle the other party to treat the contract as repudiated. In other words, as your lordship has put it, a breach that goes to the fundamentals of the contract, the principal deliverable, back to the breach of promise of marriage cases. By marrying the second lady, he cannot, under any circumstances, lawfully marry the first lady. So he has made performance of the entire contract impossible. The person who, to use again your ladyship's example, the person who sells a ship and then scuttles it before it can be delivered has made performance of the whole thing impossible. It's clearly a repudiatory breach. But anticipatory breach is not by any means, it's simply a term, it's not by any means confined to repudiation cases. You can breach a single term in an agreement, or threaten to breach a single term in an agreement, without tearing the whole agreement up. And in a case of lease, it would be very rare indeed that a breach could be so serious as to be repudiatory of the lease. But the essence of our case on 319 is that any form of license to commit any form of breach of an absolute covenant puts the landlord in a position where, if he attempts to enforce, the tenant who has got the permission will have a defence saying, I have your permission to do this, you cannot enforce this against me. Now, the objecting tenant, because this is not a letting scheme, the objecting tenant cannot enforce against what might be termed the defaulting tenant, so that the objecting tenant is then in this double position. I can no longer get the landlord to do it under 319 because the landlord cannot enforce because he's disabled himself from enforcing. I cannot myself enforce this clause because I have no right vis-a-vis another individual tenant to do so because this is not a letting scheme. So that in effect, the tenant loses the right to have absolute covenants enforced.
Well, I suppose the tenant could sue the landlord, but the landlord's got no money.
And, well, he can only sue the landlord if the landlord is in breach of contract. If my land friend is right, by granting a licence, the landlord is not in breach of contract.
No, I understand. But if the landlord is in breach of contract,
if the landlord is indeed, the only remedy is in damages, and as Lordship rightly says, in this case, the landlord is the tenants wearing a corporate hat.
Yeah.
Well, it wouldn't be something for which the landlord could impose a service charge.
No, and if the landlord had no assets, that would be it would be a sort of I would say a rather nugatory exercise.
And we're also talking about land. I mean, the tenant may want freedom from particular risks or from particular intrusions on their living space.
Yes.
For which damages would not be an adequate remedy in and of itself.
Yes. Yes.
Can you at some point, not now, help with an authority which is about anticipatory breach but does not involve complete repudiation of the contract?
I don't suppose I can. I certainly, there is none in the bundle of authorities. But the reason being that a threatened breach of contract is always been actionable, if only for a quia timet injunction. Committing a disabling act is, we would submit, in all circumstances, necessarily a breach of contract. Because by preventing yourself from performing, there is no difference between saying, I know I'm contracted to do X, but when the time comes to do X, I've no intention of doing so. That is an anticipatory breach, and it doesn't matter whether it's a very small obligation or a very large obligation. That is an anticipatory breach. Whether or not it's serious enough to justify injunctive relief would be entirely a matter of remedies for the court. But if, instead of simply saying, when the time comes for performance, I've no intention of performing, you go out and do something which has the same effect, then that is also a breach, and it's a breach at the time when it occurs, because you have put yourself out of any ability to perform when the time occurs. So the difference between the disabling act and the simple refusal is that the simple refusal, you could say, well, wait until the day for performance occurs, see if he does, and if he doesn't, sue him. But if, on the other hand, he has put it out of his power to perform the contract, that particular contractual stipulation, then waiting for performance is simply a pointless exercise, because when the day of performance arises, nothing is going to happen, because it cannot happen. This is back to, in fact, back to our breach of promise of marriage cases. The point that was taken and failed in the breach of promise of marriage case was the man argued, I can only be in breach of contract at the point where Lady 1 has asked me to marry her and I have said no. At the point at which I marry Lady 2, that has not occurred. I am not therefore in breach of contract at that point. And with that, and the court said, no, by disabling yourself, you have put yourself in a position that whatever happens, you are not going to be able to perform the contract. So at that point, you are in breach. Now, except, of course, the point made by my lady, Lady Black, that in that case, that was a fundamental repudiatory breach, because it was a refusal to perform the only obligation that was created by the contract. But the principle behind it cannot be different if it is breach, not, as it were, a fundamental breach of the whole contract, but just a breach of the one provision in the contract that is discrete and the one that is under consideration. And we say that the reason for this is not that there is an implied term of any kind. We simply say that undertaking an obligation to do something must, as a matter not simply of law but of linguistics, exclude the possibility of doing its opposite. If you go out and do the opposite, you are not in breach of an implied term that you won't do the opposite. You are in breach of the primary obligation. If, going back to my car case, if I sell my car to X, but before the time comes for delivery, I then sell the car to Y and disable myself from performing, I am then in breach of contract. What I have breached is my obligation to sell and deliver the car to X. I am not in breach of some manufactured implied term that I won't sell it to somebody else, because my selling it to somebody else is the breach. Disabling yourself from performing 319 is a breach of 319, because it is putting you in a position where you cannot perform 319. It is in our submission really as straightforward as that. And we do not have to construct an elaborate implied term And indeed, we did not. We haven't formulated one. We don't rely on one. The problem, we say, with the case being advanced by the landlord is that that does indeed import some form of implied term to the effect that the landlord can avoid 319 if he manages to grant his license before the tenant objects.
And puts up the deposit and so forth, security.
Yes, it's objection followed by offer of deposit. So if up to that point, as it were, the landlord and the tenant who wants to do the work and get their heads together and get this through, a quick, as it were, a license granted on the back of an envelope, probably wouldn't happen, but one can imagine a situation where you have a small board of directors, all of whom are personal friends, let us say, of the applying tenant, and the applying tenant comes and said, oh, I want to do this, it made my flat very much better. And the three members of the board said, well, fine, you go ahead, we know it's a breach of 2.7, but it seems reasonable to us. And only sort of a week later, one of the other tenants finds out and objects. It ought not, the enforcement of clause 319 ought not to depend on whether the objecting tenant hears about the works before the board meeting says yes, or after the board meeting says yes. I mean, that would be quite ridiculous, and of course would be an incentive to those who wished, as it were, to evade clause 2.7 or similar, to come to some sort of private arrangement with the board of directors to that effect. I'm not suggesting it could conceivably happen in Randolph Crescent, but what happens if a very rich tenant wants to do very major works, which are clearly in breach of 2.7, and he knows there's a board of 3 directors, or a board of 5 directors, he only needs 3. He goes to 3 of them and say, look, I want to do this. You know, there's 10 grand in it for you if you say yes. And they all say, well, it's a very good idea. So they all have a quick board meeting, vote to consent to the works, and take their money. Now, clearly that would be very improper behaviour in normal parlance. But if my friend's submissions are right, the permission they have given to X to do the works completely stymies any objecting tenant. The remedy of the objecting tenant would only be, I suppose, to muster the rest of the tenants and vote the board out next time there was an annual general meeting. That's not a remedy.
Well, that's an extreme example, but you might posit the case where reasonable people might disagree as to whether or not this is work that should go ahead. And the landlord thinks that it's appropriate to grant the license, but the objecting tenant does not. And as I understand your case and your submission, it would be that the objecting tenant shouldn't have the right to pursue the objection taken out of its hands by the decision of the landlord. The landlord shouldn't trump the tenant.
Your Lordship encapsulates my submissions.
Yeah.
And there's no duty of reasonableness on the tenant.
No.
There's no constraint on the tenant. They can be as...
There is no constraint on the tenant because what the tenant is asking is for the lease to be enforced. And in general, I would submit, perhaps as a very wild and general proposition, that if somebody has a contractual right which they are entitled to enforce, in most cases they are entitled to enforce it, whether it's reasonable or unreasonable to do so. That's the difference, as it were, between contractual rights, which depend on enforcing agreed terms, and tortious rights, where reasonableness may be a very major consideration. A point that has been raised, and ought, I think, to just to be considered is this. A purchaser who buys one of these leases, he and his solicitors see the lease that they are buying in advance and have a chance to see it, consider it, and consider its legal implications. Somebody who buys a lease with 319 in assumes, because that's what the 319 says, that he is getting a lease where there is a policing mechanism built in, that the landlord can be compelled to enforce the covenants because the tenants themselves can't. This is not a letting scheme, therefore we need a policing mechanism to force the landlord to act. Anybody who is happy with a situation where the landlord has a total discretion can buy into the third type of lease posited by my learned friend, normally commercial, but not necessarily, in which the landlord has sole control, the tenant can do nothing about it, it's entirely the matter of the landlord. You could buy into that, but you choose to buy into one or the other.
Well, is that realistic? I mean, you choose to buy the property because you find it attractive for all sorts of reasons. I question how often a tenant will choose one property over another because of the existence or absence of a clause 3.19.
Absence, I think one might well. Say you were buying, if you were buying a property in a small block of flats like this, where there would be a small number of tenants, a small number of people controlling the company, and personal animosities might arise, a solicitor might very well say, would you be happy with a lease in which the enforcement of the covenants is wholly at the discretion of the company? So you might not worry, if there's a 319 in, you might not worry too much about it, but a clause in which, a lease in which it was entirely at the discretion of the landlord would, I think, raise warning bells, particularly, of course, at the other end of the scale, if you had your landlord was in fact not a company owned by the tenants, but was a large impersonal commercial organisation. If it was entirely at the discretion of the landlord, you might say to yourself, well, is this landlord going to bother to enforce covenants unless it's going to affect the building as a whole or his investment in the building? So, with absent a clause 319, I think you would be wary about buying into. You might say, I so desire this property, I don't care what the lease says, I want it, I'm going to get it. But if you were, as it were, choosing, you might very well say, I prefer to have one where I've got some control over, for example, not 27, but over, for example, noise and user and so on. And therefore, the discretion of the landlord is not what I'm happy with. So I would submit that you've got to look at it from the purposes, as indeed Lord Justice Lewison, you've got to look at it from the purposes of someone who is potentially buying into this lease. I would, I think, unless there are any questions that your ladyships feel I haven't properly answered, that I think shoots my bolt. But I would emphasise that, as on the last occasion, so this is not a new position, we are saying that what we ask the court to do is to grant declaratory relief only. The casus belli in this case is, I'm probably mixing my metaphor, long since dead. The Winfield's 7 metres of wall are not going to be taken down, and they're not going to be revived. So we are simply concerned with declaring what clause 319 means.
Can I ask you what similar terms, what you say similar terms means in 319? And similar nature.
Terms of a similar nature, I would submit, means terms that are as near identical as the practicalities of the situation admit. That said, in the context of this case, and I suspect 90+% of cases where this sort of clause is in a long lease, the question will be purely academic, because every lease will from day one have been in identical terms. And there is no dispute in this case that the Winfield's lease and the Duval's lease are in absolute identical terms, mutatis mutandis.
But the reason I ask it is because if the proper analysis is that when the landlord agrees to works being done, which would otherwise be a breach of 2.7, does the lease remain in similar terms? Is that a variation of the tenant who's going to do the works lease?
Our submission is that it is not a variation of the lease, because a variation of the lease presupposes that something has been varied, as it were, not simply now but for the future, with any form of variation of contract. There is a difference between a variation, which, as it were, is prospective, and a waiver, which is partly prospective, partly retrospective, but his waiver is simply, in your case, I will not enforce this clause against you in these circumstances. And that was hence the provisions in the 1925 Act, section 143 of the 1925 Act, to the extent that if you give permission for something to be done this time, it does not bind you to grant it next time, or if you license something in breach of covenant to be done today, it doesn't necessarily license them to breach the same covenant tomorrow in a different way. That was the purpose of that. So the license, it's a license and consent. This is not in any meaningful sense a variation of the lease.
Not prevented, therefore, by 319 Part 1.
Well, 319 Part 1, I think 319 Part 1 doesn't apply at all in this case, because it posits a new lease being granted after the original leases were granted. So if sometime after 1986 a flat fell vacant, or there was a surrender or a forfeiture, and the then landlords decided to grant an entirely new lease rather than simply resurrect the old one, then that would have applied. But in this particular case, the first part of 319 doesn't apply, because these are not new leases. This would not be a new lease granted after the formation of the original lease.
One question arising out of that, I was wondering whether the formulation of the obligation in the first part of 3.19 seems, as I think you've just been submitting, to be directed to any point in time at which a new lease is granted.
Yes.
And requires that lease, when granted, will have terms of a similar nature, whatever that means. The thought was going through my mind, I'd welcome your assistance with it, whether it could be said that it would be a derogation from grant thereafter to waive or vary the terms which were originally agreed, assuming that there was compliance with the obligation in the first part of 3.19. So yes. Perhaps another way of addressing that is, I was wondering whether the structure of 3.19 is that, if you like, you fix the content of what is going to be the covenants of a similar nature to those contained in clauses 2 and 3, as at the date when a new lease is granted. And so you can check at that time, does it contain covenants of a similar nature? Answer, yes. And thereafter, whether the first part of clause 3.19 would include an impediment against variation or waiver of those terms.
Yes, I think the scheme of 319 would be that if any brand new lease were entered into of one of the flats in the building, and assume that it is on similar terms, that new lease is as subject to clause 319 part 2, as it were, as the original leases. You cannot, so to speak, evade 319 by scrapping a lease and then replacing it by an entirely new and identical lease. So in other words, as the new leases come into the building, as it were, they are then subject to the second part of 319.
Yes, my question was slightly different. I respectfully think that seems to be right. The question then was whether there was anything more to be derived from the first bit of 3.19. If the obligation is if you're going to grant a new lease, it has to contain the covenants of a similar nature, so covenants 2 and 3, whether if on the second day, having granted a lease containing those covenants, you then waive them or vary them for the future, whether that is in some sense a derogation from the grant which is contained in the first bit of 3.19.
It would be a derogation from the grant, and in addition would probably be a breach of 319 as well.
Right. So the reason I've raised this is I do wonder whether one needs to read the first bit of 319 with the second bit of 319.
Our submission is no.
Right.
And indeed it was below, and a criticism that my learned friend has made of Lord Justice Lewison is that he also took 319 to be largely irrelevant, the first part of 319 to be largely irrelevant to the second part of 319. And of course the factual element that causes it to be irrelevant is that in this particular case, that we are dealing with leases which by common consent are all identical and were all granted at the same time. So a 319 lease, Part 1 lease, never came into existence.
Thank you.
Unless I can assist the court further, those are my submissions.
Thank you very much, Mr. Morey. Mr. Mallett?
My ladies, my lords. First of all, by way of follow-up to Lady Black's inquiry this morning about plans for the works, I'm sorry, we don't believe there were ever any plans in evidence, and so not available. I can only refer your ladyship to...
You've agreed the common ground anyway,
yes,
so that's fine.
it's the Statement of Agreed Facts, paragraph 7. And if I could follow up Lord Carnworth's request for authorities on cutting and maiming and waste. We've got extracts from Woodfall and from Hill and Redman, which, if I could hand those up,
Thank you very much.
might give you a little bit of
Seen them,
assistance.
my lady, I have no objection.
We would be amazed if you did, Mr. Morey. As we'd asked for the information.
Exactly.
Well, that's going round. I mean, on the textbooks, I referred to 1330, which is Chitty.
Yes,
But that's then followed by quite a substantial section from the Lewison interpretation project, which deals with the same point.
yes.
And of course, it's Lord Justice Lewison who is there, sort of sees this as an implied term point.
Yes, indeed. So Lewison on interpretation of contracts deals with these performance-related principles as an implied term, but gives a small nod to Lord Atkin.
But that, I mean, helps to explain why he was keen on the implied term analysis in this judgment.
Yes, indeed. But Chitty doesn't even bother to consider it in any other way, any other form than an implied term, and we say that's the correct analysis. I won't take your lordships through these in any detail. You have an extract from Woodfall headed "What is an alteration?" And towards the bottom of the page, it's got some examples of cases about covenants not to cut or maim. A little bit of caution required, because obviously it depends on the exact terms of the covenant, and the ones that they start discussing are not to cut or maim any of the principal walls or timbers. That is said not to be breached by a covenant to make a doorway in an internal wall, no doubt because that wasn't a principal wall. But a covenant is broken by notching joists in order to receive air conditioning plant. So that would be the sort of thing that we've been talking about. And I would suggest a little caution is needed in relation to the next sentence, which says, where a lease contains a qualified covenant against the making of alterations and an absolute covenant against making waste, spoil or destruction, the covenant against waste will be construed as not applying to things covered by the qualified covenant against alterations. That sets out almost as if it's a general principle, what is in fact simply a point of construction on the particular lease, we happen to have the authority in the bundle. It's at page 845. And the section from Hill and Redman describes waste, and I shan't take you to any of that in any particular detail, but might give you a little bit of background.
Good, well, thank you very much.
Waste. My ladies, my lords, there was some discussion as to the relevance of the size of this building and the number of flats in it, and indeed to the question whether or not it's relevant that the landlord is owned by the tenants. Clearly, the profession most guidance from your lordships if those things weren't particularly relevant. On the other hand, they are part of the context in which these particular leases fall to be construed. So certainly I've referred you to the fact that the recitals to this lease indicate that it was part of the plan that tenants would always hold a share in the management company which was to become the landlord. That is part of the context in which these leases fall to be construed. It was suggested that our argument had the effect of turning a Category 2 kind of lease into a Category 3 kind of lease. But that is not so. The tenants under our construction of Clause 3.19 retain valuable rights of enforcement. They retain the ability to require the landlord to take steps when they are concerned about neighbour, and those are valuable. It is not something which is entirely within the discretion of the landlord. And as we pointed out in the written case, there are a number of constraints, including the first part of Clause 3.19, on the landlord's ability to sanction breaches before the tenant has taken the necessary steps to make the request.
Well, of course, there could be perfectly standard situations where the landlord either didn't know or didn't care if somebody hadn't carpeted their flat. But of course, the person underneath them would both know and care, and could draw this to the landlord's attention, and the landlord wouldn't want to grant any license to do that, or not to carpet, but might not have bothered to do anything about it had they not been required to do so by the tenant.
Absolutely, my
that's
lady.
the standard sort of situation you'd expect.
Absolutely, and particularly given that the landlord doesn't have its own assets other than its reversion and the retained parts of the building. So there may be a lot of circumstances in which the landlord isn't really very bothered about taking steps, but a particular tenant is bothered about taking steps, and the enforcement rights in those circumstances are valid and effective. There was some discussion about the distinction between...
Sorry, just on that, what about the suggestion that if you've got a very rich tenant who happens to like parquet floors throughout, and they pay the landlord not to object, but to grant a variation of the lease, what then?
Well, in our submission, my lord, that would be a deviation from the covenants of a similar nature. That would be a licence which the landlord wouldn't be permitted to give within the scope of the first part of Clause 3.19, because there is a specific covenant in the lease to deal with carpeting, Clause 2.12.2, and which requires good quality carpeting and underlay to be laid and maintained at all times in all parts. And if that clause was effectively completely excised from another person's lease, then there would not be a covenant of a similar nature to Clause 2.12.2 in that other lease. But my Lady Hale's comment that the implied term or rule or provision which the respondent seeks to rely upon would catch not just absolute covenants relating to works is absolutely right one, it wouldn't just affect absolute covenants, it would also affect the landlord's ability to grant a deviation from a qualified covenant. So, for example, if the landlord gave oral consent for works falling within 2.6, that would be a breach of those works would be a breach of 2.6. And the landlord couldn't then, on my learned friend's case, couldn't rectify it by validating that scenario. And there are a whole host of covenants which on my learned friend's case, the landlord could not depart from. The landlord is obliged to require tenants to pay 15% interest on delayed service charges. On my learned friend's case, and on the Court of Appeal's case, the landlord cannot waive its right to interest on unpaid service charges or reduce the amount of interest that is payable. The management of these blocks of flats gets almost impossible when one really follows these things through, the logical consequences through of the Court of Appeal's decision. And as regards the distinctions that were drawn between an absolute covenant in 2.7 and a qualified covenant in 2.6, I'd ask your lordships and ladyship to bear in mind that we're talking about two different leases always. So clause 2.7 is absolute as between the landlord and Mrs. Winfield. That wasn't the problem here. The landlord was happy to grant a departure from clause 2.7. The question is whether the landlord in Dr. Duval's lease has given up its ordinary freedom to enter into variations and alterations of that nature. One of the examples posited was if a licence were granted and the building was damaged, it was suggested by my learned friend that the tenant wouldn't have a right of action, or it was queried whether the tenant would have a right of action. My ladies and my lords, the tenant has a right of support granted under the first schedule of the lease, and a licence granted by the landlord which removed that support, had the effect of removing that support, would be an interference with the easement and therefore a nuisance. The landlord would be liable. And the landlord would equally have an obligation under clause 3.3.1 of the lease to repair the damage to the building. So that's a good example of an extreme case where there are already existing express provisions and rights which protect the tenants against that kind of action. My ladies and my lords, there was some considerable discussion about anticipatory breach, and Black asked my learned friend whether he could produce any authority which indicates that anticipatory breach could operate or have any effect in a non-repudiatory scenario, if I can capture it like that. He couldn't, but we can tell your ladyship that there is ample authority to indicate that an anticipatory breach is not a real breach. It is simply an event which allows an innocent party to bring the contract to an end if it is accepted and is otherwise of no effect. It is not like a real breach which gives rise to a claim for damages or an injunction as soon as it occurs. And as regards authority, the famous phraseology that an unaccepted repudiation is a thing writ in water and of no value to anybody, it confers no legal rights of any sort or kind, is Howard and Pickford Tool Company Limited, 1951, King's Bench 417. Also Furco Metal and Mediterranean Shipping Company, 1989, AC 788. And there's parts of the case of Johnston Milling, which is 1886, 16 Queen's Bench Division 460. There is a very interesting article by Lord Mustill on the history of the development of anticipatory breach. You can find, it's called The Golden Victory, Some Reflections, 2008, LQR 569. which was considered by this court in Bunge, B-U-N-G-E, and Nadira, 2015, UKSC 43. It's true that it is possible that the early cases relied on by my learned friend, like Shortenstone and Keynes and Smith, might be seen best as an early working out of the law around anticipatory breach rather than an implied term. But they're at such an early point in the development of our law of contract, and there's so little reasoning in them, it's very difficult to know what exactly was the basis for the decision. They predate both the development of the law and the law of implied terms and the law of anticipatory breach.
And there's a slightly different issue arises under clause 319 as to whether enforce includes taking action for a threatened breach. I mean, the example of if Mrs. Winfield has said, well, I don't care if you refuse me consent, I'm going to go ahead.
Yes.
And if the other tenant says, well, I want you to enforce, or surely enforcement in that context would include seeking a quiet time injunction.
Yes, indeed, and that's always been part of our case.
Yeah.
That,
So at what point on your case does if at all, does the landlord put it out of his power to license?
on our case, the landlord only puts it out of its power is only ceases to have a free hand to license a breach or prospective breach once the second part of clause 3.19 kicks in, which is once there's a breach or threatened breach and the conditions have been satisfied, that there's been a request by the objecting tenant and payment of costs.
So it includes a breach or threatened breach.
Yes.
You say we never got to that point in
We
this
never got
case,
to that
but
point.
in a sense that's irrelevant because we're not concerned with the facts of this case.
Well, we say it's important because it's important when one asks what is the term to be implied here, because the Court of Appeal held that it equated a request for a licence with a breach or threatened breach. That was part of its reasoning. And we say that that was the wrong thing to do, that there was never a breach or threatened breach, it was simply a request for a licence here. We go on further to say, if there were a breach or threatened breach, there would be no need to imply a term, that the landlord couldn't then licence those activities. Because the express provisions of clause 3.19 have not yet arisen, the objecting tenant hasn't yet satisfied the conditions, and it isn't for the same reasons as in relation to the broader implied term. It simply isn't necessary for business efficacy or obvious that the landlord should be prohibited from regularising a situation in circumstances where no other tenant has come forward to seek enforcement action. There might be lots of good reasons why there had been minor breaches where it's better for the building as a whole that these are regularised rather than that the landlord is forced to take action over. There was some discussion with my Lady Hale about what in fact happened with the works that Mrs. Winfield in fact carried out. I should say that it is a source of contention between the parties as to how exactly those matters should be described, and we do not accept what is put in the respondent's written case about that. So this is one of those matters on which I would ask your Ladyships and your Lordships simply to refer to the agreed statement of facts and issues rather than anything in the respondent's case.
Well, I was only interested in whether what had been done and permitted would amount to a breach of clause 2.7, and Mr. Morey very fairly accepted that it almost certainly did.
Yes. Essentially, what in fact happened was never put in evidence because it took place after His Honour Judge Parfitt had held that the landlord was free to grant licences. So there was no injunction or stay which prevented the works going ahead. So the evidence that had originally been put in at first instance before Deputy District Judge Chambers was not updated, and as a consequence it's entirely possible that these two parties have a different version of events as to exactly what happened, what if any breaches it involved, whether or not consent was given, whether or not objections were given. And the only safe course is to rely upon what is in the agreed statement of facts and issues.
Thinking about the continuum from the and where in the process the tenant comes in with the request to enforce. Supposing the tenant asks for enforcement, what agreed terms can be reached by the landlord thereafter, if in compromise of this problem?
Is your ladyship's question assuming that the objecting tenant has done everything that's necessary?
Yes.
So the objecting tenant comes forward, then we would say essentially the landlord is under the control of the objecting tenant so that it can compromise that dispute, it can grant a licence to regularise the position, but only with the consent of the tenant who is paying for the costs of the legal action.
And suppose that instead the tenant who wants to do the work changes the plan, so it's not the same plan to which the tenant who's objecting had objected. What difference does that make?
Well, in those circumstances, if it was different works, that would be a fresh breach.
You have to start all over again. And so the licence could be given by the landlord before the objecting tenant got in with the new objection.
No doubt there would be matters of fact and degree. I mean, if it was...
But it's just, it has a feeling of a race to the post, all of this. And I'm trying to work out the variations of that.
Yes, my lady. There would no doubt be... Then it's difficult to say, isn't it, without a particular set of facts. There might well be a proposed breach because particular works are to be carried out, and then a minor variation to those proposed works, which in the circumstances would be considered enforcement of the same breach, because you would be dealing with the same covenants that were being breached. But if your ladyship's question is about something that was completely different, then the question might be asked, why should the tenant, the objecting tenant's money, that it's put forward by way of security, be used to incur costs for the landlord enforcing something to which it might not object? And this, of course, is all bearing in mind that we are inherently talking about an actual breach rather than simply a request for a licence. It was suggested that it is our side rather than the respondents who are required to imply a term into these leases. We disagree with that. The relevant question is whether and to what extent the landlord has given up its inherent freedom to agree variations, to grant licences with other tenants. And that doesn't involve implying a term. That's a question of construing the express terms of clause 3.19, and the onus is on the respondents to imply a term if they want to say that something should go further than the express terms. And my Lady Black, you asked my learned friend about the phrase covenants of a similar nature and to what extent that a licence affects a variation of the lease. You might find it helpful to refer to the case of Topland and Smiths, which is at page 1195, Authorities Bundle 3, tab 6. It's a somewhat different context. Essentially, there was a surety for a tenant who had given absolute covenants. The landlord granted a licence for alterations falling outside those covenants, and the question was whether or not the surety had been released as a consequence of that. And it was agreed by the time the matter came to the Court of Appeal, it was common ground that the licence amounted to a variation of the lease because the lease itself had prohibited the works, but the licence permitted them. So to that extent, it amounted to a variation. And it was also held that the licence was not to be considered forbearance, which would prevent the surety being released, because it was an active authorisation. And that's the point that we make about applying for a licence is not the same as threatening a breach. And lastly, unless your lordships have anything more for me, my lord's sales point about whether it could be said to be a derogation from grant to waive or vary covenants from their original form. My lords, derogation from grant occurs, the usual test is that it is something which renders the demised premises unfit or substantially less fit for the purposes for which they were granted. And in our submission, a variation to a neighbour's lease would not in itself render premises substantially less fit in that way, so that the question about variation is whether or not the covenant itself in clause 3.19 prohibits variations. If the first part of clause 3.19 doesn't prohibit variations, then we would suggest you can't use the derogation from grant principle to fill a gap that the parties haven't chosen to agree, because the principles of non-derogation from grant will always draw their colour from the express terms of the lease. I hope I made myself clear.
Thank you very much.
My lords, is there anything else I can assist you with?
I've checked, it appears not. Thank you very much indeed. And we will now go and consider what the answer is to this not untricky conundrum with which you have presented us.